Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. Today on Legal Bites, I want to talk to you a little bit about realtor arbitration. So one of the member benefits of being a realtor and one of the member responsibilities of being a realtor is being involved with the arbitration process. We have voluntary arbitration in some cases, and we have mandatory arbitration in most cases, certainly when it's a realtor to realtor or realtor to MLS participant arbitration requests as it relates to disputes between realtors. And often those arbitrations in most cases would be considered mandatory, primarily if they're realtors of different firms, different brokerage firms. So it is a responsibility, it's also a right, and it's a great member benefit. Realtor arbitration is inexpensive, relatively speaking. So it's very cost effective. It's expeditious, and I mean all of this in comparison to either professional arbitration, which can be very, very expensive, or litigation, which can be obviously very expensive and time consuming and involve those mean evil attorneys and everything else. And so anyhow, the realtor arbitration benefit is, like I say, a benefit as well as a responsibility. So the specific area that I want to talk about in today's Legal Bites, however, as it relates to arbitration, is what often happens in a procuring cause scenario, because that's, I would say, the vast majority of arbitration requests that we receive have something to do with a procuring cause claim, a dispute between buyer agents and maybe a buyer agent and a listing broker in relation to payment of a commission and who procured the buyer in that case. So the reason I'm bringing this up is we've seen in a number of cases recently where we've had procuring cause claims come through, and I want to talk about what makes the most sense as a listing realtor when you receive a complaint or knowledge of the fact that a procuring cause claim may be made in connection with a transaction that you're currently working on. So as a listing broker, you've got a couple of options. The best option from my perspective would be if you, as the listing realtor, hear from two independent buyer brokers or buyer realtors in relation to a claim for that particular buyer that you may have a contract with or are getting ready to close with on a property, that they have a procuring cause claim. The best situation from my perspective is that the listing broker would not interfere with the transaction, and neither should the buyer agents interfere with the closing of the transaction over the commission dispute. That should never occur. There end up being real estate commission and license law violations potentially with something like that. So allow the transaction to close naturally for the benefit of the parties, but then the listing broker can escrow those funds or set the buyer agent funds aside, not pay them at the closing table. And I know that's not necessarily going to be great news for either of the two buyer agents who might believe that they're entitled to that commission, but it is, in my opinion, the safest thing for the listing realtor to do is set those funds aside, notify the parties ahead of time that they intend to escrow those funds at closing, and put them aside and say, we're not going to pay out one broker, or we're not going to make this decision here ourselves as the listing broker. We're not going to pay out one buyer agent over the sake of the other because in the event that a procuring cause claim is then brought against the listing broker by the buyer agent that wasn't paid, or buyer broker who wasn't paid, then if an arbitration award went against that listing agent for some reason, then that listing brokerage firm could have essentially had the obligation then to pay two independent buyer brokers. So the best thing to do is escrow those funds, let the parties both know, and then the next step in that scenario is to do one of two things essentially. Hopefully have one of the two parties initiate an arbitration request against both the listing realtor as well as the other broker. And so that you've got kind of three parties essentially that are involved in one arbitration. And in that case, the listing broker in most cases is going to be merely present and a party, but really mostly for witness or any evidentiary input that they may have. But ultimately what we want to have accomplished is an arbitration panel of realtor peers make a decision based on all the facts and circumstances as to which one of those two buyer agents would ultimately get paid based on the facts of the procuring cause claim. So that's the safest possibility. The other possibility would be that the listing agent could initiate the arbitration themselves against the two buyer agents to say, listen, we're holding this money. We want to get rid of it to one of you. We're not sure who. so we're going to initiate a request for arbitration. In that case, the listing broker would not have to pay any arbitration request fees or any of those fees. Both of the buyer agents in those cases, who are essentially the ones that are seeking compensation through arbitration, would have to pay the filing fee to respond to the arbitration. But once again, now the listing broker is not in a situation where they are really, they're a party technically, but they really don't have much at stake, because the only thing that would occur is the arbitration panel would make an award for delivery of those funds. So those are kind of the two possibilities. The third possibility or scenario that comes up sometimes is a situation where a listing brokerage firm does pay one of the two buyer brokers. And maybe that's because they don't have knowledge of this, the procuring cause claim from the other broker, or whatever the facts are. Maybe they just believe they're very comfortable that that whoever they paid, whatever buyer realtor they paid, was very clearly the procuring cause. In that case, the aggrieved broker who did not get paid, the buyer realtor who did not get paid, has the possibility of then initiating a complaint either directly with the other buyer agent for recovery of that fee, or with the listing agent for recovery of that fee. And that's why I think for listing agents it's probably safer to just hold on to that money in some sort of a trust or escrow account and not pay it. That way you don't potentially get a claim from an aggrieved buyer realtor who did not get paid and then ended up having to pay and disperse two funds. So anyhow, it's a little bit complicated. As always, as you go through this stuff, if you have questions, you can call the Car Legal Hotline, and I'm always happy, or the other attorneys are always happy to get you some guidance and clarification, in addition to legal matters, also on professional standards matters or realtor arbitration matters. So thank you very much for joining me, and we'll see you next time on Legal Bites.